As the country awaits the Supreme Court judgment, another landmark decision within the corridors of justice has been stirring debate amongst Kenyans. In a case where 3 petitioners took the Higher Education Loans Board (HELB) to court over exorbitant fines, they've proven victorious, resulting in a landmark ruling that saw Section 15(2) of the HELB Act declared unconstitutional. As Ngina Kirori reports, the decision by the court will see a drastic change in the way fines and penalties are imposed on borrowers.
It takes walking in the shoes of 50-year-old Jacinta Mogore to understand the problems that many students in universities experience when it comes to student loans and debt.
How can I remember?
Much as she graduated back in 1995 after her undergraduate studies, the burden of student loans has been on her shoulders since.
Now we were in the job market trying to get a job, which was really hard. For me, I started door-to-door sales. The guys who knock and tell you we have a promotion today. So that's how I started.
Armed with a degree in political science, Anne was hopeful for a future of good tidings, but that was short-lived. The nagging student loan from the Higher Education Loans Board was constantly on her mind.
I remember the time I started paying for the HELB loan was around 2002. That's when I got a good job. And I was paying 2,000 per month. And they were deducting 2,000 every month. I later came to find out they were not remitting.
A chaotic turn of events then exacerbated the situation.
I lost that job and I had a small baby, so I stopped working for some time. Then I started getting calls that I have over 500,000, 564,000. That is what I owe because of the penalties and the interest rate.
After many students pass through their graduation, the question on many of their minds is not just which job they will secure, but how they will pay off their student debt, which is why petition number E002 of 2021 is so significant. Here's what the court had to say. In the petition, Anne and 2 other petitioners, Davis Ngudu and Wangoi Washira, took HELB to court accusing the institution of being in contravention of Section 44A1 and 2 of the Banking Act, Section 43(1) and F of the Consumer Rights under Article 46(1) of the Constitution. In essence, Section 44A1 of the Banking Act gives power to the induplam rule.
I remember there was one instance with an advocate called Monica Ngere, and we were discussing generally about he borrowed 100,000. When they are paying over 200,000 now, it contravenes that in duplam when you factor in the interest and all of that. So we're wondering, why not take these guys to court? What really do we have to lose?
Ben, fresh out of law school last year.
First, we didn't believe it because we just posted it and then it blew up. And then it came at a very ripe time, because even in the US, I think you've seen President Biden waiving some student loans and acknowledging that really being charged over and above for just a degree isn't really fair.
In addition, the court found that Section 15(2) of the HELB Act is unconstitutional. The section states that any loanee who fails or neglects to satisfy the requirements of subsection 1 within the stipulated time shall be guilty of an offence and liable to a fine of not less than 5,000 shillings in respect of each loan deduction that remains unpaid in accordance with provisions of subsection 1, and such fine be payable to the board. For Anne, the case was not only about finding relief from the inflated amount of money HELB demanded from her, but also on why they failed to give proper notice when her debt was building up.
If they had just sent me an email and told me like you're not repaying your HELB loans, then I would have been able to run after these companies, because right now one of the companies has gone under.
With an osteoarthritis condition, Anne says that work has been hard to come by. Coupled by the fact that she does not have her clearance certificate from HELB, she has had to contend with doing odd jobs to earn a living.
We have so many jobless. I was actually, the time I was working as a matatu conductor, and we were so many graduates doing it. This is something that is it's in the right direction. It's good. At least it will give us, for those who are able to pay, at least you'll not be slapped with so much. Some have even overpaid. Like they have paid all those fines, and that money could have been utilized to do something else.
However, the promoters of the petition say the silver lining of the suit is the positive impact it will have on social protection. NTV also attempted to reach out to HELB to find out what changes, if any, this will have on the issuance of student loans, but we did not receive a response. Gena Kirori, NTV.